Good evening, everybody.
Good evening, sir.
Can you guys hear me?
Yes,
Can
we can hear
everyone
you,
hear me?
sir. Yes, sir, we
Okay,
Yes.
that's fine.
can.
That's fantastic. Is the mic working? Is it clear?
Yes, it is.
Okay. Yeah, I'm glad that it is. So, once again, good afternoon, everyone, and welcome to um the Dieko Daniel School of Law and our module one for our class task. Initially, I said that we did not need to have certain interactions. Of course, we are not, so to say, having interactions when it comes to the nitty gritty of the course itself, because I believe that most of those things have been uploaded on the school website already. So you all have the lecture videos, I believe, and everyone has watched the lecture videos for module one of criminal litigation, I believe. Please, if you have, you can tell me that you have. Can everyone hear me?
Yes, sir. Yes, sir. We can hear you, sir.
So you have watched the videos. Okay, very good. Ernest Blessing said that he has watched the uh, lecture videos for mode one. So therefore, we are just going straight to what we have today, right? This is supposed to be scheduled for 1 hour 30 minutes, and in 1 hour 30 minutes, we make our class discussion. We talk about everything that we need to talk about mode one, and that's the end. After that, you are supposed to have um your test, right? The test is not a big issue. It's not like, no, test. It's just for us to know if the students are following what is being taught and they understand what is being taught, right? So although you're going to be graded, right, which makes it quite important. But I think that the substance of importance here shouldn't necessarily be the test as much as it is the mock trials. I want to make sure that you have enough knowledge in the mock trials. Also, for the test, I'm trying to accustom you, for those of us that are going to law school very soon, I'm trying to accustom you to the way law school sets questions and things like that. So, um, well, I think that there is the rule that everybody's video should be turned on, and I cannot see anybody's video turned on. Please make sure you are muted so that this class can be a seamless class. And thank everybody. I can see people's faces now, and I can see that they are actually listening as well. One of the reasons I said that we need to have our videos on is because this is the fifth edition, so to say, of the course, right? And um, I know when we have editions like this, that most of the time students are either cooking or washing plates or they are doing something sharp, and then they just use one ear. They'll be using one ear to be listening. They are not here 100%. I just want to make sure. Kindly mute yourself. Kindly mute yourself. LS Blessing, kindly mute yourself, please. Israel Omitogun, kindly mute yourself as well. So I just want to make sure that everybody is giving me. I want to be seeing your faces like this. I can see you looking at me. For example, I can see Divine Okuse, I believe, is very, very serious looking at the screen. I'm wondering if it's actually me he's listening to. Okay, now he's smiling. Now that has to be me. Okay, very good. And I can see Oluwa Titi Titi Lope Taiwo also looking very serious. Is this the same criminal litigation that everybody's looking serious for like this? Why are you people so serious? Smile, exactly. You need some bad smile. You have a very cute smile, by the way. So let's go to the class now. Let's go to the class now. First of all, I would say that I am extremely disappointed at the fact that the number of turnouts for the class task for this week for module one. I'm extremely disappointed. Let me honestly tell you, because out of I think about eight, I'm not in charge of the administration, right? So the person who is in charge of the administration is the one who creates the groups and does the whole thing. I'm in charge of the lecture and making sure that your lecture is done. Do you understand that you get your lecture and, as you can see, interface when it comes to the lecture? So when I asked her how many groups submitted, she told me that only one group submitted. I'm like, one out of eight groups. You people must think that this is a joke, right? Um, First of all, I need to underline the fact that this is not a joke, right? This is very serious. This is all of a sudden I'm not seeing them Ogen Emaro. You are showing me your fan. Please let me see your face. The essence of telling you to put on your this is to see your face. Also, Oyelola Oladiti, I want to see your face. Thank you very much. Again, Emaru, I did not say I want to see your hair. It's beautiful, by the way. I acknowledge that. But I also want to see your face. Yes. Thank you very much. Oyilola Oladiti, I'm still seeing your ceiling. I'm not talking to your ceiling, please. Okay, so moving on. I'm extremely disappointed, and I hope that by next class, of course, there's going to be a massive turnout. Thank you, Inola. There's going to be a massive turnout when it comes to submitting the class task, and we are not going to um, have to talk about why. I'm not going to ask you why, because I know that there might be certain reasons that you would think valid, I would not think is valid, right? So I'm going to give you the benefit of the doubt that whatever reason it is that you are going to give to me is valid, right? But from next week, no reason is going to be valid. Teaching officer said, where are we to submit? You are supposed to submit to the administrative officer. She's the one who will communicate with me that this so number of students submitted and all that. You understand? So you submit to her. I had a certain complaint from I think group 3. I had a certain complaint from group 3 that none of our team members decided to participate in the lecture. A certain complaint from group 3 that none of the team members decided to participate in the lecture. And I think that after this Zoom meeting, I'm going to drop a message on the group chat that if you are not going to participate, please tell us that you're not going to participate so that we can know the people that are serious, right? One, your appearance here, we take it into consideration before giving you certificates. Your test, we take it into consideration. Your attitude to class, we take it into consideration. At the back end, I can see how many videos you have watched, how long you spent watching those videos. We take it into consideration. So we take a lot of factors into consideration before we eventually give you the certificate. Don't think that at the end of the day, I paid now, so I will get a certificate. No. It's subject to terms and conditions. And those terms and conditions is that you must do all the things that the school has told you to do. So your presence here is extremely important, right? Into considering whether or not you will actually get the certificate, your test, also your mock trial, and a lot of other things. Now, for the rest of the groups, you guys already have one strike, apart from the group that submitted today. Right? You guys already have one strike, right? You are supposed to 3 strikes and you will not get a certificate, right? Every other team member of every other group, apart from the girl who submitted to me personally and the girl who submitted to the administrative officer, the group who submitted to the administrative officer, every other person has 3 strikes. And all of them have 1 strike now, so they have 2 strikes left, right? And that is how we are going to run the administration of the school, so that it keeps you on your toes. You don't think that you are going to do anything anyhow, and that's equator. No, it's not going to work. You understand? So having said that, I think it's time to go straight into the nitty-gritty of today's class, right? So it's basically on our class task. How many of you actually read the class task? Please, if you did, let me know. You can unmute yourself and let me know. So I just got the information that group 5, group 7, and group 1 just submitted. So I thought, I don't know if I'm supposed to submit. It's all right. That's fine. We'll talk about the groups. So I can't see anybody saying that they actually read the class task. Did you guys read the class task?
Yes, I did.
Okay. Olaya, yes, said we didn't know who to submit to. Okay, moving forward, we are supposed to submit to the administrative officer. So can someone please read out the question 1 for me? I'm going to be calling group 5. Or in short, I'm going to be calling anybody at random here to speak, right? So that we can answer the question. Trust me, if you can fail, you cannot know the answer. It is normal. This is your opportunity to fail. Where it is not going to be right for you to fail is where you are in your externship or internship, and then your principal asks you a question, and you're like, I don't know, you call it catch. That is where you ought not to fail, right? Here, this is your learning process. This is your learning ground. When I was at law school as well, there were certain questions that my lecturer of school would ask me that I would not know. So it's normal. You understand? And you guys are even ahead of time. So it's normal for you not to know. Do you understand? So let's not say, oh, please, I don't want to embarrass myself. You are not embarrassing yourself. You are learning. You understand? So to question 1, is there someone who is so kind enough to read question 1 for us, please? So it's currently 3:25. So we have roughly an hour to read this. Please let's be fast so that I know everybody, we all have things that we are doing. So I just want to take 1 hour 30 minutes and we are done for the week. Next week we'll do another. So please, Can someone read? Okay. Olaya, please read for us. You have been telling us this morning that you did not know where to send to. Yeah. Read for us.
Hi, Dieko. Okay.
How are you? Yeah, I'm listening.
So, question one.
Yeah.
Broccoli standing trial at sitting at Igboshere for conspiracy to commit armed robbery, being in possession of substance suspected to be cannabis sativa in a charge filed on 10th February 2019. His counsel,
Okay.
while addressing the court, relied on the Criminal Procedure Act and Administration of Justice Law of Lagos State 2007, as both applies in the South, and invited the court to adopt the procedure applicable in the High Court of England for bail application.
Okay.
Prosecutor violently objected to the flagrant misapplication of the law and the jurisdiction of the court. The court subsequently adjourned for parties to file and adopt their written addresses relating to the objection.
Yeah.
However, on the eve of the adjourned date, due to heavy downpour coupled with excessive windstorm, the courtroom was flooded and the roof off. On the adjourned date, the presiding judge elected to sit in a nearby uncompleted primary school hall. Counsel for both prosecution and defense adopted their written address, even though they both complained that the sitting was a kangaroo court sitting in view of the venue, as it was not the designated courtroom. Okay, at the end of the day sitting, both counsel agreed with the judge in chambers that the nature of the case, that the court should sit on a Saturday and the next Monday in a public holiday, as their witnesses being public servants will be free on those days to testify. The defendant was eventually convicted and sentenced accordingly for one of the counts. He intended to appeal in grounds of miscarriage of justice as the court sat in a Saturday and public holiday. Should I read the questions?
No. We'll get to the questions. Now, is there anybody who, while they were reading this, they got lost at certain points? Let's have a discussion. Did you get lost? Was it foreign to you at any point? Let's start with you, Olaya.
Actually, no.
What is it?
Not really.
Okay, because I believe that if you have gone through the class, you'll be like, oh, okay, I've heard of this. It shouldn't be foreign anymore, right? Because there are things that we discuss time and time again on the classes, right? Eunice, Obasum, was it foreign to you when you read through the question?
Sorry, I didn't hear you well. Was it foreign to me when I did what?
Did you understand the question? The question itself was quite lengthy, but did you understand it?
Yes, I understood the question.
Okay. Were you able to answer the questions well when you read through the questions themselves?
Yes, I was. Yes.
Okay. Very good. So, for the sake of clarity, because I know that Titilayo was a little bit, our network was cracking a little bit. So, for the sake of clarity, especially for those who are going to watch this video over again, I'll just go through what she said, the questions she read. So, Brooklyn Abagi is standing trial at the Lagos State High Court, sitting at Igboshere for conspiracy to commit armed robbery, right? Armed robbery itself, being in possession of substance suspected to be cannabis sativa in a charge filed on the 10th of February 2019. His counsel, while addressing the court, relied on the Criminal Procedure Act and the Administration of Criminal Justice Law of Lagos State 2007, as both applies in the South, and invited the court to adopt the procedure applicable in the High Court of England for bail application. Prosecuting counsel vehemently objected to the flagrant misapplication of the law and the jurisdiction of the court. The court subsequently adjourned for parties to file and adopt their final written addresses relating to the objection. However, on the eve of the adjourned date, due to a heavy downpour coupled with excessive windstorm, the court was flooded and the roof blown off. On the adjourned day, the presiding judge elected to sit in a nearby uncompleted primary school hall. Counsel for both the prosecution and defense adopted their written addresses, even though they complained that the sitting was a kangaroo court, sitting in view of the venue, as it was not a designated court room. Now, at the end of the day sitting, both counsel agreed with the judge in chamber that due to the nature of the case, that the court should sit on a Saturday and the next Monday being a public holiday, as their counsel being public, as their witnesses rather, being public servants, will be free on those days to testify. The defendant was eventually convicted and sentenced accordingly for one of the counts. He intends to appeal on grounds of miscarriage of justice as the court sat on a Saturday and public holiday. So now this is almost everything I think that we talked about in our module 1, right? We talked about sources of criminal litigation, we talked about criminal litigation itself, we talked about the sitting of the court, we talked about the setting of the court, right? Who can tell me what other topic was in module 1? Let's look at Israel Omitogun. What other topic did we teach in module 1? Okay, I think there's something wrong with his network. For some reason, he can't actually hear me. We have 28 participants. Okay, I'm talking about people whose video ought to be on. We have 28 participants here, and only about 8 people's videos are on. I don't understand. Not that I have to see your face. So the attendance in itself is of the people who I can see their face. If I cannot see their face, in court, there is something that they say. When you are not properly ruled in court, the judge will say that I can see you, but I cannot hear you because you are not wearing your full regalia, right? I can see you, but I can't hear you. Or I can hear you, but I can't see you. I can't remember which one it was. I think I'm mistaken. I think that I can hear you, but I can't see you. So, for all other participants, it's deemed that you are not here. I want to, except those people that took excuses, right? They told me that, oh, for certain reasons, they will not be able to. And also from my administrative officer, they got excuses from her. So if that is the case, then of course. But apart from those ones, I'm sorry. So moving on, I think Israel Mitogu's network has a problem. So let me go to Aino Ifeoluwa. What were the courses taught in module 1?
So, can you hear me?
Yeah, I can hear you.
Oh, okay. In module 1, we learned the meaning of criminal litigation,
Yes.
comparison between civil and criminal proceedings,
Yes.
sources of criminal litigation, types,
Yes.
sitting and setting of the criminal courts. So
Yes. That's very good. Thank you very much, Aino Ifeoluwa. It's important for you to know all these things, right? Because for some reason, these are the things that we tested in your MCQ today. I went through the question because it was the administrative officer that said it. I went through the question and I was like, okay, every single thing I actually taught in the course. So there are 15 questions, by the way, and that's going to be for, is it 10 or 15 minutes? I don't know yet. The MCQ questions, so they are going to be very easy. You just look at it, answer your question. Can you mute yourself, everybody? So now let's go to our first question here. Now, comment with the aid of judicial and statutory authorities on the following. Number 1, judicial and statutory authorities on number 1, the reliance and applicability of the Criminal Procedure Act and the Administration of Criminal Procedure Law of Lagos State, 2007, in criminal trials in Lagos State in the above trial. So let us start with who be scholar for here. Let me call scholar. There's someone that is strong in face like scholar. You see that boy who smile. Divine, answer that question 1. You look like scholar.
Good afternoon, sir. I don't know if I look like one, but I will try.
Your voice is sounding like you sound like a lawyer. You sound like counsel. That's good. Yeah.
The reliance and applicability of Criminal Procedure Act and Administration of Criminal Justice Law of Lagos State, 2007, in criminal trials in Lagos State, in the above trial, is applicability of Criminal Procedure Act is not proper.
Yes. So we are supposed to comment So they are telling you to comment, right? So we are commenting on the reliance and applicability. So the first thing you're supposed to tell me is whether it is proper or it is not proper, right? So
Yes, it is not proper because
it is not okay because
yes,
this is because
the issue was initiated as the Federal High Court.
okay.
Of which, if it were the State High Court of Lagos State, then the ACJL of Lagos would have been applicable.
Well,
But then by
can you read first line? Read first line. First line of the question. Do you have the question? First line of the question. Do you have the question with you? Am I the only person who lost divine? Okay. Probably when he comes back, we'll continue. Let's go to the next person. Who are those people with fine faces? Taiwo, your face is looking fine for question 1. Tell us.
Okay, can you hear me now?
Yes. Okay, I can hear. Was that Taiwo?
Yes, can you hear me?
Oh, very good. Finally, scholar, you're welcome. Yes, I can hear you. Please, can you answer question number 1A for us?
Okay, I think I would agree with the first person that spoke earlier because
Fine.
this is not proper. Is
Yes.
of the fact that it has been instituted of a federal high court.
I didn't hear that. Can you go over your reason again?
Okay. Not a federal high court. Yes, this act actually industrial court.
You are breaking terribly. I can't hear you. Like I can't really hear what you're saying.
Can you hear me now?
Yes, I can hear you now.
Okay. I said that it does not apply at the state high court.
Okay.
But it applies at the federal high court, the national industrial court.
What is it which does not apply?
The reliance on the Criminal Procedure Act and the administration of
is it the CPA that does not apply or the ACJL Lagos?
I think both. The CPA is actually
they don't apply where?
It applies at the Federal High Court, the National Industrial Court, and
the CPA applies at the Federal High Court.
Yes. No, not anymore.
Okay. Yes, not anymore.
Yes, sir. But the administration of Lagos, I think,
yes.
Is this in Lagos? Yes, it still applies in Lagos, but this is not a federal court. So
okay, I think you know what you want to say, but I'm not getting the point. I know that you understand the rules, but now this is why we need that interaction. Because understanding the rules is one thing. Now, ability to apply. You have seen the scenario and they've asked you, the CPA and the ACJL 2007, does it apply in this case? I want you to tell me whether or not it's proper when the council raised it. I want to tell you your reason as to why it is proper or not, and any authorities you can furnish me with, and then your submission, that's press, right? So someone said, can we offer answers to the question? Why not, please? Thank you so much to Titi Lokwe Oluwa Taiwo. Thank you. I really appreciate that. Please stay in a place I can always call you. Don't go and sit yourself in that class where I can't talk to you. Okay, thank you. Yeah, I'm serious because I don't think I could hear you in the class. So who is the person who wanted to speak? Was that Olaya?
Yes, it's me.
Yes, Olaya. I cannot see you.
Yes, I'm actually turned on my video call.
Yeah, I can. Yes, can you speak?
Sorry, what question are we asking first? Let me have the question asking.
Question number 1 on comment on the CPA, the applicability of the CPA and the ACJL in the criminal trials in Lagos State. That's what we're talking about.
Okay.
Yeah.
So for me, I believe that CPA and it's not proper, and CPA
has been repealed already
The
by
CP has been
ACJL 2007. And also, using ACJL 2007 as well is also not proper
sorry,
because
1 minute.
it has also been
One,
repealed.
I wanted to correct you there.
Can you hear
CPA
me?
was, yes, I can hear you. CPA was not repealed by the ACJL Lagos. CPA did not even apply to Lagos. It was the
Oh,
CPCL that applied, CPC rather, that applied to Lagos.
sorry,
And then the CPC
CPL
applied.
repealed CPA.
What did you say?
That's forgetful. I said CPL repealed CPA.
CPL repealed CPA. Okay, yes, because it made it inapplicable in Lagos State. Okay, that's the CPC or CPL, yes? Yes. You can continue.
Saying that ACJL, okay, I was saying ACJL 2007 is not applicable because it has been repealed and reenacted as ACJL 2011. And even ACJL 2011 is still not being used now because there's ACJL 2021 right now. So I don't think any of the laws are even proper to be used because the current one has is ACJL 2021. So yeah, that's my
Thank you
submission.
so much. Tiwalayo Olaya. That's a very beautiful submission. Although the way you placed it, I did not understand. But I got the entirety of what you're saying. And it's actually a very, very beautiful submission. So yes, the reliance on the applicability of the CPA and the ACJL in this trial, that's HCJL 2007, it is improper. Why? This is because the CPA has been repealed by the CPL or CPL in the north, in the south rather, which is applicable to Lagos, and the ACJA in federal court. Also, the ACJL 2007 has been repealed by ACJA 2011, which we now have another ACJA 2015 and ACJA 2021. And the extant law to be used in a Lagos State High Court ought to be the ACJA 2020, ACJL rather, Lagos 2021, right? That's the extant law to be used. So that ought to be your submission, right? Let me see. Can you give me a group? Let me see what the group said. While we do that, let's go to the next question.
Sorry, dear, I want to ask you something. I want to ask you a question.
Yes, please. What's your question?
To be sure. Are you awarding marks for participation and answering questions?
What did you say?
Are you awarding marks for participation and like asking questions or answering questions? Are we getting marks for it?
I wouldn't say awarding marks, but at the end of the day, there's going to be like an overall best counsel and all that, best student and all that. These are things that we put into consideration before we give that. We don't just arbitrarily just say, oh, you have a very fine face. So, yeah, you should be our, no, doesn't work like that. So we look at a lot of things. We look at also class involvement and see, for example, Olaya has given a very impressive presentation, right? So we record that, and you know your presentation, your speech, and all those things go a long way when we are finally awarding certificate and giving merit and all that and all that. Do you understand? Okay, I think I'm not getting an answer there. Probably the person muted herself. So looking at Group A said that the reliance and acceptability of the CPA and ECJ Lagos is invalid. This is because they have been repealed by Section 419 of the ACJ 2015. Therefore, the council erred in this regard. I think I like the way they answer their question here. This is how I want you to answer your question. Although I would not say that their reason is so correct, right? But this is especially what I'm talking about. So kudos to Group A for answering the question in that manner. Can somebody give me the question 2? Can I see the next question?
The legality of the court proceeding held in an incomplete primary school building.
Okay, the legality of the court proceeding held in an incomplete primary school building. Can someone please speak as regards that to us, please? Okay. Since nobody would like to speak to us, Ayodeji Victor, can you please speak to us on this issue? You don't disappear. Please don't disappear. Oh.
So on this issue, the legality of conducting the proceedings in a primary
Yes.
school is not, because an incomplete primary school is not a designated place to achieve justice. Therefore, the
Okay.
setting of the court.
Okay. Let me see. Let me see what the group said. Any of the groups. Okay. So someone said it is legal. A vital characteristics of the court is easy access to the public. Section 200 of the Administration of Criminal Justice Law 2015, as well as Section 36 of the Constitution of the Federal Republic of Nigeria, requires the court to be in a public place. Hence, such proceedings are valid. Which group is this? Group 4, Success, Chinagorum, Benita, Rita, and Afolayan Okoyemi. I don't think they are here today, but this is an extremely brilliant answer, and that is the answer. So
Well,
apparently, I already wait. I will speak on it. Don't worry. Even we too, when we were at law school, and this question came out, and our lecturer said, we said, of course, it has to be a courtroom, right? Because that's the reason why we have courtroom. Our lecturer said the judge is the court. Do you understand that? The judge is the court. Anywhere the judge decides to sit, so far the requirement of the Constitution has been met. What is the requirement of the Constitution? Easy accessibility to the public. Easy accessibility to the public. So far the Constitution, the condition of the Constitution has been met. Then, even if it is under a tree, make judge sit down. They just carry table, sit down for tree, right? And then he just says, hey, you, begin to testify. Hey, you, this chair will be the doc. This chair will be the witness box. That is the courtroom. Do you understand that? Although it is less likely that will happen, but in any unfortunate instance where that happens, do not say that because it is not a designated courtroom, it is not a court. The judge is the court. Wherever the judge decides to sit, so far the condition of accessibility as stipulated by the Constitution has been met, that is all that is needed. Does anybody have any question on this before we go to the next one? Any question? Ogenemaru, you look so serious. Is everything all right? Okay, very good. I can see. I saw your gesticulation. Who else? Israel Lutoku is always looking like policeman. Israel, is everything all right? Okay,
Please, I
yes,
want
your
to ask a
question.
question.
Yeah, I'm listening.
So the requirement is that it must be a public place, or is it that it must be a public place, or wherever the judge chooses to sit, that's where it will be.
Wherever the judge chooses to sit, wherever the judge chooses to sit, so far it is accessible to the public. The judge can decide to sit in his chamber and then open the chamber to the public. The judge can decide to sit under the tree, and then it must be accessible. It's possible to sit under the tree and then lock the gate to the compound where the tree is. That is not accessible to the public. Therefore, that cannot be a courtroom. Whenever a judge has stipulated the condition for a judge, he has been elevated to the position of a judge. Wherever that judge decides to sit. When I was at River State for my court extension, if you look at the magistrate court that they had there, that magistrate court has to be one of the shittiest magistrate court I've seen. It was just basically one room. Apparently, they were building, Wike was building the new magistrate court. So it was just one room that they just, I don't even know. The judge's seat was just an elevated place. They just happened to elevate the place. Every other thing was terrible. I did not know if that place was a courtroom or a prison yard because they looked the same. Do you understand? I did not know what it was, but at the end of the day, it became a courtroom because of two conditions. Because the judge chose to sit there, and because it was accessible to the public as mandated by the Constitution. So I think that we are done with that. Please let's go to our next question. What's the next question, please?
Announce your appearance in writing as if you were announcing it orally from the magistrate's court to the Supreme Court.
Oh yeah, announce appearance before this court.
Sorry, good evening, everyone. Can you hear me, please? Can you hear me, sir?
Yes, we can hear you.
Okay, so I'm just going to try. The magistrate court,
Yes.
oh God, with utmost humility to your worship, my humble appearance
Hey,
for the
that power
defendant,
now with utmost humility.
that is for the magistrate court.
Say it again.
Utmost humility to your worship,
Yes.
my humble
Yes.
appearance is for the defendant, for the magistrate
Okay.
court. So for the high court, may it please this honorable court. Oh, I'm so sorry, I made a mistake in the first one. Sorry, for the magistrate court, with
Okay.
utmost humility to your worship, I am OG Oladisi, and my humble appearance is for the defendant.
Okay.
For the high court, may
You
it
don't
please
tell
this
us what.
honorable court. For the high court,
Yeah.
may it please this honorable court. Appearing
Yeah.
before your lordship is OG Oladisi, and my appearance is for the defendant. So
So
for
your
the
name is
appellate court,
OG, right? Your name is OG.
with yes, sir.
Can you hear me? Oh, OG. Is that right?
Yes,
I
Mr.
continue.
I can hear you.
Yeah, yeah. For the appellate court, is there a way you appear in the appellate court? Let me hear this your professional submission. Talk now, we're listening. Okay, so I don't think I can hear Oladiti anymore. I don't know if anybody can hear. I think our network has gotten an idea. Okay, so let's continue. Now that is very wonderful from her actually, but she's distinguishing between the high court, the at your level when you are playing before the court. My lecturer would say in law school, just use one. What's the one? Um what does the lecturer say? Yes, may it please this honorable court. That's what the lecturer says. May it please this honorable court. Just use that. Use that. Now, when you are comfortable, that is when you now start saying, with profound respect to this honorable temple of justice. With you know, those are people who are just putting a jata. You know when you are trying to show that you sabi law, you can say with profound respect, with profound humility before this court, blah blah blah. Do you understand? Or with profound humility before this honorable temple of justice. But the simple one, may it please this honorable court. Appearing, that's the first line. Or the first line is you wind the judges. That's the first thing you do. You greet them, right? May it please this court. Then your second line is now introducing yourself. Now, introducing yourself, she said her name is OG Oladiti. Our lecturer will say that you should abbreviate your surname abbreviate your surname and your other name and call your name. So normally I'm supposed to introduce myself as OD, Dieko, right? But I usually introduce my full name most of the time when I'm introducing. So I'm like, I appearing before this court is Olayeni Dieko Daniels, right? I don't used to abbreviate my name because even when we had mock trial in school and the judge, a real state high judge was there, I did not abbreviate my name. I called my full name because I'm already used to it. So, but normally in court, they usually abbreviate names, but you can do without abbreviating your name. I'm just letting you know. That is, and then the third thing. So the first thing, may it please this honorable court. The second thing, appearing before this court is Olayeni Dieko Daniels. Then the third thing is what? I'm announcing my humble appearance for the defense or for the prosecution, or appearing for the prosecution. Whatever it is, you shall tell us that you are doing it either for the prosecution or for the defense. So three things. When they say announce appearance, may it please this honorable temple of justice, appear before this court is Olayeni Dieko Daniels, and I'm making my humble appearance for the prosecution in this case. There are certain times where you are going to appear with other people, but you also have to introduce those people before the court. So you will stand up and while you are addressing the court, the next thing, which then becomes the fourth thing, appearing with me is OG Oladiti, for example, right? Then she will stand up, bow her head, then sit down. That's how to appear, right? Whether or not you're in the magistrate court, you are in the federal high court or you are in the appellate court. Some people just like adding a jasa when they are saying with profound humility before this court, with profound respect before this court, blah blah blah. Do you understand? But this is the traditional way. So with that, we move to the next thing, the next question. Levi, you can read it for us.
As a senior member of the bar in Abuja and as a human rights advocate, comments
Yes.
as to the sitting of the courts.
So in the setting of the court, I don't think we need to talk too much about that, right? In the setting of the court, you know there is where the judge stays, is known as the bench. There is the registrar's desk. In front of the registrar is the inner bar, right? These are things that you ought to know. In front of the inner bar is the bar. Then after the bar is the gallery. Then you have the judge and the witness box. Simple. That's the setting of the court. It's not something difficult. I think that's straightforward. So these are things that we would know naturally, right? Let's go to question number 2 so that we can round this up on time. Levi, please, can you read question number 2 for us if you have it?
As the proceedings of the Federal High Court in Yenegua, Bayelsa State, on a 2-count charge of the illicit trafficking in drugs and unlawful trespass to land against Yankari Ayula and Badachi Olanikpopo. Counsel for the defendants objected to the reliance of the proceeding. Learned Prosecution State Counsel Kalingo Brown from the Office of the Attorney General of the Federation, in his reply, argued that the objection of learned counsel to the defendants is misconceived because Criminal Procedure Act and Criminal Procedure Code is and has always been the applicable procedural law in criminal proceedings in the Federal High Court, irrespective of where it is sitting. Comments with the aid of statutory and legal authorities on the following: the propriety or otherwise of the institution of the matter in the Federal High Court.
Okay, that's very good. Can somebody give us the answer to that? This one is quite technical, actually. This one is a little bit more technical. I don't think I've taught you criminal jurisdiction. I know that I mentioned this when I was teaching, but we've not had our class on criminal jurisdiction, right? The class in itself on criminal jurisdiction, where we are going to look at matters that are within the exclusive jurisdiction of the Federal High Court, right? Treason and treasonable felony, right? But I don't think that, we've talked about that, but I know that during my teachings, I usually speak in very broad spectrum. So as a result of that, by implication, I believe that this would have covered one or two things that I must have mentioned during the class. But at least as at now, with the knowledge that we have on criminal litigation so far, can someone tell me what the answer is? Is it proper? So they are talking about the propriety or otherwise, right? Is it proper or not? Basically, that's the grammar. The propriety or otherwise of the institution of the matter in the Federal High Court. So can someone give me a response to that, please?
Good evening.
Good evening. Yeah, I can hear you.
Okay, the question is whether or not the matter is proper for a Federal High Court to adjudicate on the matter.
You're welcome.
Thank you. Good evening.
Good evening. Yes, so what's your answer?
Yeah, my answer is that it is proper because the Federal High Court, the Federal High Court is a special court that adjudicates on special cases. And one of those cases deals with matters that has been defined by the National Assembly. That is any crime that has been defined by the National Legislature. And illicit drug trafficking is among them because it's defined by the National Drug Law Enforcement Agency, which is an act by the National Assembly. So yes, it is proper.
What about the issue of unlawful trespass to land? Is that something within the jurisdiction of the Federal High Court?
Unlawful, no. So but unlawful trespass to land is a civil wrong and not a criminal offense.
Okay. So first of all, I want to say this is very beautiful from you, actually, Gift. It's a very beautiful answer. I like your answer so much. So first of all, when we're talking about unlawful trespass is civil. Yeah, we were talking and I said, Gift, I really love your speech, right? So this falls within the jurisdiction of the Federal High Court. Why? Because we are talking about illicit drug trafficking, and illicit drug trafficking are things you find within the Federal High Court because they are within the exclusive jurisdiction, within the exclusive list. Therefore, only the National Assembly can make legislations on them. One of the legislations the National Assembly has made is the NDLEA Act. And as a result of the NDLEA Act, the court with the jurisdiction to hear matters regarding things like this would be the Federal High Court, right? So, Gift, that was actually very, 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 very wonderful. I'm really impressed by a lot of people today, actually. You know, apart from the fact that you people disappointed me, first of all, I'm still pained from the disappointment. Apart from the fact that you guys disappointed me, I am actually quite impressed by a lot of you. Okay, so moving on. Yeah, so I think we've gotten the answer for question number 1, right? Everybody can hear me adequately, I believe.
Yes, we can.
Okay, so I think we've gotten the answer for question number 1, which is it proper to institute the matter? The answer is yes, it is proper. There are 2 matters here. One is civil, one is criminal. Criminal trespass would have been criminal, but in this case, it is unlawful trespass, which is civil. So there's only one criminal offense here, which is illicit drug trafficking, which falls within the jurisdiction of the Federal High Court. And that is the answer. It is proper. Thank you very much, Gift, for that very beautiful answer. So now let's go to the second one, which is the propriety or otherwise of the objection of learned counsel to the defendant. Is that the second?
Yes.
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 Okay. So before we get there, please can you open any group's answer? So what was the objection? What was the objection? So counsel for the defendant objected to the reliance of the prosecution on the Criminal Procedure Act as the applicable procedural law to the proceedings. So can someone give me an answer? Before you give me an answer, let me look at number 2. Okay, this group did not answer question number 2. Mind you, I'm going to mark this thing and send it to everybody. I'll send you answers. I'll mark it and send your answer to everybody to show you that. But I'm talking about my administrative officer, though. She will mark it and send the answer to everybody to let you know what you are doing right and what you are doing wrong. So we are receiving it, we are reading it. So it's not as if I'm just giving you a goose chase and telling you to do something. No, I'm receiving it and I'm reading them. I think number 2 has already been hashed in our question number 1, so that we will not waste time. We all know that the CPA is not applicable in the Federal High Court. Everybody knows that by now. If you don't know that, they're supposed to flog you. Because this is the point of this, what we all know, that is the ACJA that is applicable to where? The Federal High Court, the High Court of the FCT, and the NIC, National Industrial Court. Any criminal proceedings brought in these 3 courts must be adjudicated by the through the what is it called? The ACJA, right? And not the CPA. Let us not dwell on this. We have more important things to talk about. Right? And because we already have very little time left. Now,
the propriety otherwise of the response of the prosecution counsel to the objection. Is that what we just did?
No. We did the objection by the counsel. Now, the learned state counsel from the Attorney General's office in this reply argued that the objection of the learned counsel to the defendant is misconceived, because the Criminal Procedure Act and the Criminal Procedure Code is and has always been applicable procedural law in criminal proceedings in the Federal High Court, irrespective of where it's sitting. So we are supposed to speak as to the propriety or otherwise of that. Can someone speak to us as to that? Divine, I feel like you should be able to look for it. You should be able to speak as to it.
Objection of legal counsel to the defendant. Okay, in my opinion, his objection is improper.
Okay, why?
Because the Criminal Procedure Act, that is the CPA and the CPC, do not apply to the Federal High Court. It is the Administration of Criminal Justice Act 2015 that applies. And by virtue of this section 2 sub 1 of ACTA 2015, The act shall be applicable in any criminal trial involving any offense established by an act of National Assembly. So in this case, the ACJA is the proper status that is applicable, not the CPA or the CPC.
Yes, you are very right. So you can see that this is us trying to let you know that we have reacted to this point over and over and over again. And I feel that because of this, we all have this fundamental knowledge already, right? And that's a very good thing for all of us. So now with that, law school itself is not hard, right? Once you are able to find very good lecture on the subject matter that you are learning, everything is easy. The hardest thing, and I feel that is the hardest because they always talk about it, the hardest thing that you are going to learn in law school for criminal litigation is charges, how to draft charges, the rules in drafting charges, rule against ambiguity, rule against duplicity, rule against misjoinder of offenders, and rule against misjoinder of offenses. You see, as easy as it is that I said it now, if you know the number of exceptions that are inside this thing and how you are going to apply them when you are drafting, you will know that this is crazy. And I'm very sure that when I teach it, and people start telling you that drafting charges is hard, you're like, what is hard about it, right? So this is extremely easy. And also, don't forget that this is, in as much as we are learning the criminal litigation part of it, the essence of this whole thing is for mock trial. This course is for you to be able to sharpen your advocacy skills, right? So you know that I already released 33 videos of mock trials. Very soon we are going to start our mock trial. So I want you to start preparing towards the mock trial. Start opening your schedule, because I know you people now, you'll be forming Dangote and big men, Airfish, Oyema. I'm so sorry, Mr. Dieko. I'm going to be busy with my school is something. I'm sorry, we have an essay. Please, during the time when we are going to start our mock trials, I want you guys to have 100% attention, because trust me, you're never going to have anything like this again. Right after this school, you're not going to have any other school, any other person come sit you down and teach you in this context ever again. So if I tell you to sit down and do the mock trials, please sit down and do the mock trials. They are very important, right? So this is how we are going to be having our classes till we end. Now, I know that when you were enrolling in the course, this was not the timeline that was given for your classes. The timeline that was given was that we're supposed to be done by the end of April, right? We're supposed to be done by the end of April. But law school and Council of Legal Education, we were supposed to do our course bar by January. They said no. We were supposed to do our course bar by February. Again, they said no. They now did our court bar in March. That was what disrupted a lot of things, right? Because of the court bar. So I'm trying to make sure that I put everything back in perspective. And please, I'm begging you, I need your 100% seriousness, right? This is not okay, I will do it, I will not do it. I need you to be 100%. I want to thank the groups that sent in their assignments today. I'm going to make sure that they are marked, they are graded. The rest that did not send, they already have their strikes, right? Because I don't know why the school will tell you, we group you and tell you to do something, and then you decide not to do it. Of course, you are going to have your strikes, and then you guys are going to have your scores, right? There are going to be a lot of division of those scores. At the end of the day, you have your scores as a group for giving us such a wonderful presentation and all that. But during the course of the lecture, I just want to do a little bit of feedback. I know if you have any questions for the school and anything that you want to sort out, anything you think you want to speak about. I think this is the time for you to speak up. Is there any question regarding the school that you don't know or something, or is there anything about the lectures that you don't understand, or anything at all that is bothering you
I have
that
a
for some
question.
reason? Okay, please, I'm listening. Who is
I don't know if
speaking,
you can
please?
hear me.
I can hear you, but I don't know who is speaking.
Okay,
Who is
yes,
speaking, please?
it's Tiwalayo. It's Tiwalayo. So I wanted to ask, when you're marking our group ups, are you going to send us the correct answer alongside, or it's just today's class? Because I was able to pick some things up because of the network. That's why I'm asking if you're going to still send the answers to us.
To you. The class is recorded, right? We are going to make sure that the links are available for you to be able to watch it, so that your learning will be premium. You will not have any reason to say, I did not learn, I did not. There is nothing like that here, right? Video, your lecture classes, so which means you can watch them at any time. This is just for 1 hour, 30 minutes for us to have a discussion and for me to be able to talk with you and know that you are getting what is being taught by the school. And at the end of the day, you still get the links and still watch the videos at your own time. But that doesn't mean that you should not be here because there's attendance. We need to have a discussion. So, like, yeah, I believe that answers your question, right?
Yes, yes.
Okay, thank you very much. Okay, is there any other question by any other person? Amarachi said, please, what about members that didn't join the group for the assignment? Okay, that's a very brilliant. If a member did not join the group for the assignment, don't bother yourself. Just make sure that you have done all that is necessary to make members join. You can't force them to join, can you? You are here as an individual to learn, right? But the only thing about learning is that it is better when it's done in a group because you guys are going to make mistakes, laugh about your mistakes, and learn together. That's the major reason why we are grouping you. But if other people say they are not going to join, quote and unquote, there is nothing that you can do. So learn, but just that put the names of the people that are doing these assignments that are engaging, put their names on the group, right? Those are the names that are going to be awarded the marks, right? And we'll also forward the answer after we marked your group, will forward it to you. So for those people that do not want to join, that's their business. So amongst the people that have been serious so far, we are going to regroup those people that have been serious, and we'll then group you into groups that we are going to conduct mock trials for. Do you understand? Because honestly, I cannot drag somebody to come and you are not going to collect certificate of participation. You are not going to collect certificate of merit. You have access to the videos, you have access to all these things, access which will end when the course ends. But I will not give you certificate because I cannot attest to your knowledge. Someone like Olaiya now, or someone like Divine and all that, I have interacted with them. I know that yes, these people attend lectures, these people speak to me, I have spoken with them. Someone like Obi Gibb, someone like Eunice Obasun that smiles a lot, Ayodeji Victor, Israel Umitogun, and Elo Gene just went to one side, just went to one corner. I think she came late. I did not see her in the beginning of this call. I think she came late. So, but I know that I've seen her one or twice, but she just went to one corner. Oyinlola Oladiti as well. I know Ifeoluwa must have used jazz for me because I did not call her a lot of times. I will see you in my next criminal task where we call you a lot. And then I think there is an Onyinye who wants to speak. Onyinye, please speak. It's just that I don't see why you are speaking without your camera.
Okay, sorry. It's just because of the noise.
The noise affected your camera?
No, the noise outside my house. A lot of children are playing up and down.
We want to see them. They are children. We want to see them. We have no problem with them. Please let us see your face. Is it
okay? My question is regards to the video that you. My question is regards to the video, criminal litigation video that was posted. I saw 5 the other day, but today I saw only 2. That's why I don't know if it's
not 2 videos. Does anybody have any problem, any similar problem like that? There were 5 videos and now there are 2.
No, I don't.
I don't think that's. Thank you so much. I don't think that's possible. Maybe it's your network or something. Try to refresh, reload, or do something. I think it's your network. Now there are 6 now, so they are not 5 because I started recording module 2. Module 2, which we are going to talk about. Note that next week we are likely going to do 3 modules: module 2, module 3, and module 4. So next week we are going to have like a lot of classes because we want to end the school on time. So we are going to talk about module 2, which is on arrest and searches. Module 2 is on arrest, searches, and summons, right? How to arrest effectively. You know this criminal litigation, right? So if you are going to work in a Ministry of Justice or you are going to work in a criminal defense firm, right? Although they used to say that criminal litigation does not have money. Don't mind them. It's true that it doesn't have money, but still don't mind them because when the senators that steal, when they come to your place, it is the experience of the ones that did not have money that you are going to use for the senators that steal. Because the senators that steal, the governors that steal, no be lawyer they defended, now corporate lawyer they defended. Definitely not, right? So we are anticipating for their stealing, so we can anticipate for their defense. right? You get the point. Very good. So please don't mind when they say that there's no money in criminal litigation. So we are going to talk about arrest. We are going to talk about searches and all that. So when you are working in the criminal defense law firm, and your boss tells you that a client has been arrested, one of these you should look at, especially if the person was arrested out of jurisdiction. What is the procedure for arrest out of jurisdiction? We have to learn that, right? When the person has been issued a warrant of arrest, what must be in the content of the warrant of arrest? That's something we are supposed to learn. When the person's house has been searched, right, without a search warrant, what is the implication of the evidence that has been gotten from the person's house when there was no search warrant? Imagine the way I'm inside my house right now. Police just burst inside, bam, open the door, and then they start carrying my things, carry my laptop. Let's say I'm a Yahoo boy. They carry my laptop, carry my phone, and then they search into my laptop and my phone, and then they show some incriminating things. And that evidence which they found from my phone and laptop in my house without a search warrant, can it be used in my criminal trial? That is the question. Do you understand? Those are the answers that we are going. Those are the questions that we are going to give answers to by our module 2. Then after our module 2, we continue to other topics. I hope you have been. I think that's where we end. Where we end this meeting for today. It is a very convenient point to end our meeting for today, especially because Gift is currently saying, "Mr. Dieko, are you sure you don't want to leave now?" Gift, I'm leaving now. I know. I'm leaving now. Okay, so. Again, is there any question that anybody wants to ask before we leave? I'll just give our 10 seconds for questions. 1, 2, 3. Okay, I don't think there are any questions. So thank you so much. I think that there are more female. Yes. Okay, yes. I think there are more female participation here than there are male. Divine and Israel Omitogun and Ayodeji Victor and one other person. Please, I need you people to come with full force by our next class. You people should bring the boys. The girls are winning us when it comes to this. I see all their faces. What happened to boys? Please. Boys must be the one that will get this best grant. I don't know. I just want somebody to get. She said it's going to be a girl. Okay, let us see who it's going to be. So yes, 15 minutes away. I'm going to give you guys 15 minutes break. 15 minutes away, we are going to have our MCQ test immediately. So as people are getting off, go and drink water, go and refresh. Don't worry. Who is this? Hello, again. You don't start up first. Hey, Jesus. MCQ, calm down. It's not deep. Trust me, it's not deep. It's just to for us to know. We want to see the response. Okay, they are learning. That is the only thing. We want to see the response. Don't take it to heart, right? Tests like this are not necessarily a test of your knowledge. It's during your advocacy time. You see you go be cancelled. I want to see you say, my Lord, the witness, I want to see that. Do you understand? That is the real deal, not necessarily the test. The test is just to give us feedback and then we respond. So please, after this, make sure you go and rest for like 10 minutes, close your head. This is not the time to open book. For all the people that have not been reading, this is not the time. Go and rest. Drink cold tea water and maybe come alive if you have. Chilled one, go and drink it, rest, so that your test you can get it. You understand? So thank you so much for being here today, and I think that this has been a fun criminal litigation class. I hope you enjoyed yourself. For those people who did not talk, I will make sure you talk by next class. Hello, Gene, I'm still talking to you. You will talk by next class. And for others, Abraham, is at the end that you not paid your fees. That's good. I will see you in next class.
Sorry, because I have a question.
Hey, Jesus. Now, when we don't be close. Okay,
no, sir, I just wanted
question?
to ask the quiz. Are we going to? Should we answer it now? Like immediately?
Now, our test is the quiz. Now, our test is the quiz. Is that the quiz? Okay,
yes, sir.
It's test.
The test, quiz. Sir. Okay, yes. The test, sir. Should we answer it immediately? You drop it. Immediately you send the test question.
Yes, should we answer it then? You are going to be given 10 minutes to answer the test. The test itself might not time you, but between so time to so time, every response that we receive are the responses that will be recorded. So let's say what time now? Let me just give the time here. So this is 17:38. So let me say by 6 o'clock on the dot. The reason I said by 6 o'clock on the dot is I can give you our close here. I can give you all time gist and rest. By 6 o'clock on the dot, you must be online to answer the test. By 6:10 on the dot, any response that we receive will not be recorded. It is 6 o'clock to 6:10. So you are timing yourself. The moment is 6:11. Any response you give will not be recorded. Network disturb you, no disturb you, you know to concern. Know this. So make sure that if you know your phone has network, go and go home. Go and meet your neighbor. Neighbor, please, I need phone. You understand, because network issue is not going to be it's not going to be an excuse. Nothing will be an excuse. You must do your best. Do you understand that? So I feel with this we've answered all questions. Thank you so much for being here. I want to excuse myself. I think I need to charge my phone for the test. Don't worry, we are already leaving. We are already leaving. Thank you so much, Obi Gift. And thank you every person who participated in today's task. We are going to continue our task. Same time next week, Saturday. We will see you there. Bye-bye. Thank you so much for being there.